Rule 124. Procedure in the Court of Appeals. Section 1. Title of the case. In all criminal cases appealed to the Court of Appeals, the party appealing the case shall be called the appellant and the adverse party the appellee, but the title of the case shall remain as it was in the court of origin. 1a. Section 2. Appointment of counsel de officio for the accused. If it appears from the record of the case as transmitted that, a. the accused is confined in prison, b. is without counsel to part on appeal, or c. has signed the notice of appeal himself, the clerk of court of the Court of Appeals shall designate a counsel de officio. An appellant who is not confined in prison may, upon request, be assigned a counsel de officio within 10 days from receipt of the notice to file brief, and he establishes his right thereto. 2a. Section 3. When brief for appellant to be filed. Within 30 days from receipt by the appellant or his counsel of the notice from the clerk of court of the Court of Appeals that the evidence, oral and documentary, is already attached to the record, the appellant shall file 7 copies of his brief with the clerk of court, which shall be accompanied by proof of service of 2 copies thereof upon the appellee. 3a. Section 4. When brief for appellee to be filed, reply brief of the appellant. Within 30 days from the receipt of the brief of the appellant, the appellee shall file 7 copies of the brief of the appellee with the clerk of court, which shall be accompanied by proof of service of 2 copies thereof upon the appellant. Within 20 days from receipt of the brief of the appellee, the appellant may file a reply brief traversing matters raised in the former but not covered in the brief of the appellant. 4a. Section 5. Extension of time for filing briefs. Extension of time for the filing of briefs will not be allowed except for good and sufficient cause, and only if the motion for extension is filed before the expiration of the time sought to be extended. 5a. Section 6. Form of briefs. Briefs shall either be printed, encoded, or typewritten in double space on the legal size good quality unglazed paper, 330 mm in length by 216 mm in width. 6a. Section 7. Contents of brief. The briefs in criminal cases shall have the same contents as provided in sections 13 and 14 of Rule 44. A certified true copy of the decision or final order appealed from shall be appended to the brief of appellant. 7a. Section 8. Dismissal of appeal for abandonment or failure to prosecute. The Court of Appeals may, upon motion of the appellee or motu proprio and with notice to the appellant in either case, dismiss the appeal if the appellant fails to file his brief within the time prescribed by this rule, except where the appellant is represented by a counsel de officio. The Court of Appeals may also, upon motion of the appellee or motu proprio, dismiss the appeal if the appellant escapes from prison or confinement, jumps bail or flees to a foreign country during the pendency of the appeal. 8a. Section 9. Prompt disposition of appeals. Appeals of accused who are under detention shall be given precedence in their disposition over other appeals. The Court of Appeals shall hear and decide the appeal at the earliest practicable time with due regard to the rights of the parties. The accused need not be present in court during the hearing of the appeal. 9a.
Gcash is a domestic online application which is the best app to use when paying bills. You can also invest in the stock market using this app and an app to buy life insurance. Try it now. See the link in the description of this video to get 50 pesos cash rebate.
Section 10. Judgment not to be reversed or modified except for substantial error. No judgment shall be reversed or modified unless the Court of Appeals, after an examination of the record and of the evidence adduced by the parties, is of the opinion that error was committed which injuriously affected the substantial rights of the appellant. 10a. Section 11. Scope of judgment. The Court of Appeals may reverse, affirm, or modify the judgment and increase or reduce the penalty imposed by the trial court, remand the case to the regional trial court for new trial or retrial, or dismiss the case. 11a. Section 12. Power to receive evidence. The Court of Appeals shall have the power to try cases and conduct hearings, receive evidence, and perform any and all acts necessary to resolve factual issues raised in cases, a. falling within its original jurisdiction, b. involving claims for damages arising from provisional remedies, or c. where the court grants a new trial based only on the ground of newly discovered evidence. 12a. Section 13. Quorum of the court, certification or appeal of cases to Supreme Court. 3. Justices of the Court of Appeals shall constitute a quorum for the sessions of a division. The unanimous vote of the three justices of a division shall be necessary for the pronouncement of a judgment or final resolution, which shall be reached in consultation before the writing of the opinion by a member of the division. In the event that the three justices cannot reach a unanimous vote, the presiding justice shall direct the raffle committee of the court to designate two additional justices to sit temporarily with them, forming a special division of five members, and the concurrence of a majority of such division shall be necessary for the pronouncement of a judgment or final resolution. The designation of such additional justices shall be made strictly by raffle and rotation among all other justices of the Court of Appeals. Whenever the Court of Appeals finds that the penalty of death, reclusion perpetua, or life imprisonment should be imposed in a case, the court, after discussion of the evidence and the law involved, shall render judgment imposing the penalty of death, reclusion perpetua, or life imprisonment as the circumstances warrant. However, it shall refrain from entering the judgment and forthwith certify the case and elevate the entire record thereof to the Supreme Court for review. 13a. Section 14. Motion for new trial. At any time after the appeal from the lower court has been perfected and before the judgment of the Court of Appeals convicting the appellant becomes final, the latter may move for a new trial on the ground of newly discovered evidence material to his defense. The motion shall conform with the provisions of Section 4, Rule 121. 14a. Section 15. Where new trial conducted. When a new trial is granted, the Court of Appeals may conduct the hearing and receive evidence as provided in Section 12 of this rule or refer the trial to the court of origin. 15a. Section 16. Reconsideration. A motion for reconsideration shall be filed within 15 days after from notice of the decision or final order of the Court of Appeals, with copies served upon the adverse party, setting forth the grounds in support thereof. The mittimus shall be stayed during the pendency of the motion for reconsideration. No party shall be allowed a second motion for reconsideration of a judgment or final order. 16a. Section 17. Judgment transmitted and filed in trial court. When the entry of judgment of the Court of Appeals is issued, a certified true copy of the judgment shall be attached to the original record, which shall be remanded to the clerk of the court from which the appeal was taken. 17a. Section 18. Application of certain rules in civil to criminal cases. The provisions of Rules 42, 44 to 46 and 48 to 56 relating to procedure in the Court of Appeals and in the Supreme Court in original and appealed civil cases shall be applied to criminal cases insofar as they are applicable and not inconsistent with the provisions of this rule. 18a. Earn passive income from sales by promoting product links of Shopee, Lazada, Zalora among others. Just generate the affiliate link and post it in your social media. If someone buy, you will earn commission. Check out the link on the description to get rewards.